Alrighty, so we have a small update in the Dak Prescott lawsuit and police investigation. There's a lot of noise going on. I did a full video on it. I will link to it in the description. A lot of interesting stuff in it. But in short, Dak Prescott had filed an extortion lawsuit against a woman named Victoria Shores after she and her attorneys had sent a letter, and I should mention that the attorneys are named in the extortion suit, asking for $100 million to not go ahead and report an alleged incident from 2017 stemming from a strip club parking lot. Now, after Dak Prescott filed that suit, Victoria Shores went to the Dallas Police Department and filed a police report. And today's news is the police are not charging Dak Prescott. They did their investigation. They said there's insufficient evidence and it's not moving forward. That's not the end of the legal movement going on, though. On April 16th, Victoria Shores attorneys withdrew their countersuit filing in Dallas County without prejudice. They could refile there if they wanted to, but they withdrew it to move it over to Collin County, where Dak Prescott is filing his civil suit. So bringing it all together. Additionally, Victoria Shores attorneys have filed a motion to dismiss, citing the anti-SLAPP statute. So we'll look at that a little bit too. But as far as what the police found, this is Dallas County. This was the police investigation. And again, that police report was filed. Victoria Shores went and filed this, not just after Dak Prescott filed his, extortion claims and said he was going to the police to report extortion attempts. But it was also after she and her attorneys sat for separate interviews, which was interesting timing, and I talk about that in my previous video. But here, let's sum it up. We have Dallas police will not pursue sexual assault charges against Cowboys quarterback Dak Prescott, with a police spokesperson saying Thursday detectives determined there was insufficient evidence an offense was committed. The case stemmed from an alleged incident that occurred in 2017, in which a woman said Prescott assaulted her in the back of an SUV in a strip club parking lot. In March, Prescott filed a suit seeking monetary relief in excess of $1 million after receiving a letter in January from attorneys Beth and Joel Zehaie on behalf of the woman, stating that they would, quote, forego pursuing criminal charges along with disclosing this information to the public in exchange for compensating her for the mental anguish she has suffered. The woman's damages were valued. And when they say were valued here, it was valued by the attorneys writing the letter. That's where the valuation came from. They gave it this number of $100 million. The woman filed a countersuit and criminal charges after Prescott's initial filing. And then we get a quote from Dak Prescott's one of his attorneys, Levi McCathern, that says, I want to thank the Dallas PD and Dallas County District Attorney's Office for their thorough investigation of the allegations against Dak Prescott. As we knew they would, they found nothing in their extensive exploration of the facts that would support a criminal prosecution. We are confident that at the end of law enforcement's investigation into the extortion case, that they will find the accuser and her attorneys just as guilty as Dak is innocent. As I've said from the beginning, Dak is a great football player and an even better human. He would never assault any woman. These false accusations were brought up 7 years after the alleged events for one reason and one reason only, to line the pockets of the accuser and her attorneys. Their behavior is an affront to all the true survivors of sexual assault. So Victoria Shores attorney Joel also released a statement in response to this, saying that it unfortunately takes a while for victims to come out, and that makes it very difficult to prosecute these cases. He vowed that he and Bethel vowed to continue their legal fight on behalf of their client. And honestly, themselves, because they are named in the extortion suit. We are proceeding with our counterclaims, even though Levi McCathern is using every tactic to prevent us from going to court, including attempting to order the law enforcement of the Dallas Cowboys against us. So the Prosper Police to come after us. What? Including attempting to order the law enforcement of the Dallas Cowboys against us. The Prosper Police Department. Why would you word it that way? You're referring to the police department, characterizing the police department as if it's the entity. It belongs to the Dallas Cowboys. On Monday, the woman's attorneys filed a notice to dismiss Prescott's suit because it violated Texas anti-SLAPP statute. In an email, Joel said that the statute prohibits many forms of retaliatory lawsuits, including ones meant to silence sexual assault victims. We're in the process of setting it for a hearing and are also still moving forward with the counterclaims. One of the cases we are citing is one that Dak's law firm has successfully argued and won. If we are successful, Dak could face severe monetary sanctions. Now, I'm personally going to say that this part here sounds like puffing smoke. You're citing a case that they successfully won. But is it a case on point? Are the facts similar? You know, a lot of stuff with SLAPP, anti-SLAPP, involves prima facie considerations. Are the elements there that we should take this case forward? It doesn't mean that the elements are proven or agreed to by a fact finder. It's just, is there substance? Is there evidence that could establish all 4 elements required for something like defamation? So here, this to me seems self-serving. It's like, oh, we're even citing them and we're using their argument against them. Well, if their case, if they successfully won it because the person bringing a suit against that person, that client at that point in time, on its face didn't meet the required elements to move forward, that would be why it would be dismissed under anti-SLAPP. But if you apply it to the same scenario, and we read the whole filing, we read Dak Prescott's whole filing, if the filing has enough there to establish the elements necessary, then anti-SLAPP would not apply. You can't just say, oh, Levi McCathern has gotten something dismissed under anti-SLAPP before, so we're going to use that against them. That's not how it works. And then look at the next paragraph here. McCathern, so Levi said that the Zehaies have misrepresented the relevant facts and misconstrued the law as it applies to them, adding that they intend to file claims against the defendants for malicious prosecution. So wait, there's going to be more. Last month, the woman's lawsuit was dropped in Dallas County and moved to Collin County because Prescott's initial suit seeking damages was brought in that county. Now, this was a withdrawal. Zehaie, they said that they withdrew this case to refile it in the other venue. So this is a little bit vague. Let's be detailed there. And I do want to say there was another quote here from Yoel in relation to the police investigation ending. We thank Dallas Police Department for their efforts, and this is in no way an exoneration of Mr. Prescott. And I do want to note some things that are mentioned in this NBC Sports article titled Anti-SLAPP Motion to Dismiss is filed against Dak Prescott's lawsuit. They open by saying the extortion lawsuit filed by Dak Prescott might have opened the door for his alleged victim to sue him for sexual assault. It has also sparked a motion to dismiss under, I think that's supposed to be under, the legal concept known as anti-SLAPP. But let's focus in on why would this open the door? So Mike Florio. Sometimes it pays to take an aggressive and proactive approach to the court system, sometimes it backfires. For Cowboys quarterback Dak Prescott, it might have backfired. Earlier this year, Prescott received a demand letter from lawyers who represent a woman who accuses Prescott of sexual assault. The alleged incident happened in February of 2017. The biggest problem regarding a potential civil lawsuit alleging sexual assault against Prescott came from the applicable statute of limitations. Put simply, it was too late for the alleged victim to sue Prescott for sexual assault, which is, we talked about in the other video, possible reason why a demand letter was sent, because the demand letter didn't just say, pursuing some type of remedy through this channel. It also said, if you don't want us to go public with it, go to just publicity. Tell people, because the statute of limitations was up. Prescott and his lawyers reacted to the demand letter, which sought payment of $100 million, by suing the alleged victim and her lawyers for extortion. And under Texas law, that apparently opened the door for Prescott to be sued for the alleged sexual assault that would have fallen outside of the statute of limitations. Why? Because under the Texas Civil Practices and Remedies Code, there's this language here. If a counterclaim or cross-claim arises out of the same transaction or occurrence that is the basis of an action, a party to the action may file the counterclaim or cross-claim, even though as a separate action it would be barred by the limitation on the date the party's answer is required. It goes on to say that, as we know, Prescott's alleged victim did indeed file a counterclaim against Prescott. We know that it was originally filed in Dallas County and it's been withdrawn and then moved over to Collin County. The counterclaim alleges defamation, intentional infliction of emotional distress, sexual assault, and false imprisonment. The counterclaim, and I want to note here, false imprisonment, but her friend, she claims that she had her friend drive behind her to go back with Dak Prescott. They were in the car with Dak Prescott's driver for the night. But the friend drove behind them, alone, while she got back in the car with Dak and rode with Dak.
Whenever I was walking around him, he held my hand. So it's not like I could just run away or walk away. So I saw my friend, I said, come back with me and take me to get my car. So we got in the car, same setup pretty much. He led me to the back, the very back, and he was pretty intoxicated, so he actually fell asleep. And we went all the way back to his house. She followed us, and I told her to take me to my car.
I'm not really sure how they're going to make this false imprisonment or where they're going to say false imprisonment would have occurred in the timeline of her story. And again, it was her story, her telling. The counterclaim itself has few details. I wonder why. This is the full extent of the allegations regarding sexual assault. Prescott is liable for sexual assault due to him intentionally or knowingly causing the penetration of the sexual organ of counterplaintiff without her consent. Well, if you're making a whole argument saying, motion to dismiss, anti-SLAPP, and you're trying to cite Levi Catherine's previous case success against him, but one of the things that would have made that successful is he was able to make a prima facie showing of the elements of the cause of action being met. But then your counterclaim has few details. What is the evidence to meet the elements required for this cause of action? That's interesting. Maybe we can read the thing in full. Maybe we can read the counterclaim in full. Prescott's primary defense is and will be that the sexual assault didn't happen. However, if he hadn't sued first, he wouldn't have to deal with that claim at all. Well, this is tricky, right? Because, there's this idea of litigation abuse. But what happens when someone sends a letter with a header from a law firm? You can argue that that's litigation. That's not just someone sending a text message. That's a letterhead with attorney information sending you some type of demand. That's litigation. So really, the first move was that letter. And this statute here is so vague that I'm not sure that what they're trying to say, open the door here, will really carry weight. And all the while, there will also be probably, I'm expecting, a motion to dismiss the counterclaim filed by Levi McCathern and his team. So for now, Prescott's lawyers will likely try to argue that the sexual assault does not arise out of the same transaction or occurrence that is the basis of the action. Since the lawsuit arises not from what? The 2017 assault, but from the alleged effort to extort Prescott. I haven't researched the issue, so that's this guy saying, I don't know. But there will surely be a fight over whether the extortion lawsuit does indeed open the door to the sexual assault claim. This is a great paragraph. Shout out to them. Because that's where I was thinking, So that's our update. But guys, whether you're new to this case or you knew about the initial filing and what was going on, what are your thoughts now knowing all of this? And also let me know if you want to take a look at the counterclaim, if I can find a PDF upload of it somewhere. We can go and take a look at that counterclaim and see what we think. Any other questions you have, drop them in the comments, say hello, and you guys all take care. Have a great day. See you next time.